Very good afternoon, everyone. Is the audio and video clear? Confirm whether audio and video both are clear. I'll wait for another 2 minutes. If anyone has to join, please join fast. So let us start with the today's session on Limited Liability Partnership Act for the CA Inter May 24 examinations. So in the first class we completed all the basic concepts. Now we are going to discuss about the concept relating to section number 5, 6 and so on. Some important sections are there. Let us cover those and complete. Once all these are completed, then we will be going into the next area of discussion called as incorporation of LLP. Incorporation of LLP. There are 7 sections surrounding the concept of incorporation. We will also complete them. Okay. So let's begin. See the screen. First, we have completed up to advantages. First response from everyone joining the live. Are you all comfortable up to here? Shall we begin with the concept? I mean the yesterday's concept. Are you all comfortable? We can start with the directly the concept, right? Okay. And before we start, please share the video with your friends as well. Please share the video with your friends as well so that they can also join. So if you complete in live, that will have a different impact. After that, listening means again you may postpone your listening part. So please complete live. So please share the video with your friends. Also, please share the old video as well. I mean the day before yesterday's class as well. Please share it with your friends. So let's begin. See here. Concept is section number 5. What is the concept? Partners. Let us start reading the Bare Act first. Okay. Like any other day, like any other concept, let us start with the Bare Act. Once you complete the Bare Act of section 5, we have another connected section for this. What is a connected section? That also I will show you. Listen first. Any individual, you and me are individuals, or body corporate, LLP, companies, all these are body corporates, may be a partner in LLP. That's why, if you remember in the last class itself, I told you, who can become a partner? Any person can become a partner. When I say person, what do you mean by person here? Any legal person. Need not be artificial. Whether natural or artificial, legal personalities can become the partners in a partnership firm, being a limited liability partnership firm. However, an individual shall not be capable of becoming a partner of LLP if means We are now going to discuss about disqualifications of becoming a partner. What is the concept? Disqualifications of becoming a partner. Okay. When? What are the grounds of disqualification? Let's understand. He has been found to be of unsound mind by a court of competent jurisdiction and the finding is in force. He is an undischarged insolvent or he has applied to be adjudicated as an insolvent and his application is pending. Okay, in these cases such kind of individual can't become a partner of an LLP. That's the point. Now the question arises, what do you mean by this disqualification concept? Simply, disqualification concept will apply only in case of individual. If you are an individual, you should not be falling under any of these three categories. If you fall under any of the three categories, you are not qualified, rather you are disqualified from becoming a partner of a LLP. Here, an individual shall not be capable of becoming a partner of LLP if he. Whenever I use the word he, it's talking about a individual. It's not talking about a entity. Number one. Number two, as per General Clauses Act, he includes she. Whenever I use the word he, so then if she is unsound, she can become a LLP partner. No. No, they use the word he. He always includes she. That's what section 13 of General Clauses Act says. General Clauses Act section 13 says that whenever act uses a masculine gender, it also include female genders in that, unless specifically context wanted to convey something. Okay. First, I will give you 2 minutes time. Read this. After that, we have another linking section to this. That also we will read. Merge both of them, completed. Read it. 2 minutes time, please. Those who are joining live, please concentrate properly. Complete everything in the live itself. Reading. Everyone, live. Reading. Okay, so let's continue. See here, there are certain technicalities in this section. Listen, again I am telling you, there are two ways of reading a section. Number one, reading it as it is. Number two, reading with enough amount of interpretations inside it and interconnections. I will give you examples first. Whenever you read this section, one can read this section independently. Means what? Independent reading of section means as if there is no interlinkage, as if this is the only section on this area. You can read this section and you can leave. That is one way of reading this section. There is another way of reading this section. That's a right way of reading by putting some interconnections to this. Open section number 24. Yes, 24. Okay, section 24. In section 24, subsection 2, let us read. Subsection 2. A person shall cease to be a partner. A person shall cease. Cease means discontinue or stop. Okay. A person shall cease to be a partner of LLP on his death or dissolution of LLP. Reason number one. Or if he is declared to be of unsound mind by a competent court, or if he has applied to be adjudicated as an insolvent or declared as an insolvent. These are the three words that are being used. Okay, read this. Read subsection 2. I have one important question. If you read subsection 2 of section 24, we can make interlinkage. Okay, so let's begin. See here. So the meaning. What are the two sections that we are interconnecting now? There are two important sections to interconnect. Number one, section number 5. Number two, section number 24b. 24, sorry, section number 24.2. In section number 24.2, how many points are there? 3 points are there: A, B, and C. Section number 24, subsection 2, clause A. 24, subsection 2, clause B. 24, subsection 2, clause C. How many are there? 3 things are there inside this. These 3 verses, one side section number 5 is there. How to interlink and read? Okay, let me first explain what is the logic behind this. See here. Here space is available, I am writing here. There are 2 sections. Section number 5, section number 24, subsection 2. Section number 5 will be talking about disqualifications to become partner. 24.2 will be talking about vacation of office of a partner. Sir, what is the difference? I will explain. First section talks about before becoming a partner. Second section will be talking about after becoming a partner. How to understand that? To become a partner, these are the disqualifications. After becoming a partner, if you are attracted by subsection 2 clause A or B or C, then your office will be vacated. Simply vacation, also called as cessation. Auditor ki casual vacancy is there. That means vacancy is there. Like that, this is the partner's vacancy concept. Means 24.2 is talking about vacancy in the office of a partner. 5 is talking about disqualifications before becoming a partner. Means if you are attracted by section 5, if you are attracted by section 5 before becoming a partner, you can't become a partner because you are disqualified. Second, if you are already a partner, later section 5 disqualifications are attracted on you. In that case, your office will become vacant under section number 24 A, B and C. Section number 24, subsection 2 A, B and C. So from this, what we have to understand? We have to verify section 5 conditions before becoming a partner, section 24 conditions after becoming a partner. 24 conditions after becoming a partner. Let us first try to understand section number 5 and section number 24.2 combinedly. How to read an answer when two sections are talking about the same subject matter. Now we are going into the harmonious interpretation. Now we are going into what interpretation? Harmonious interpretation of what and what sections? Section number 5 and section number 24.2. Okay. Now, let's come to section number 5. Read this now. Take a minute time, read it first, please. Okay, tell me, how many disqualifications are there for becoming a partner? How many disqualifications are there from becoming a partner? Everyone, how many disqualifications are there from becoming a partner? Three. Okay. How many grounds of vacation are there from becoming a partner? How many grounds of vacation are there from becoming a partner? Everyone, so live students, you must participate. Please complete it in the live itself. Don't take the burden again at home. Complete in the class. If I complete 10 pages, 10 pages you complete along with me. Such that you need not read again and again the same concept. Okay. So technically, to understand the logic, there are 3 grounds of disqualification. How many are there? 3 grounds of disqualification. And there are 3 grounds of vacation as well. How many grounds of vacation? 3 grounds of vacation are there. But if you subdivide them, there will be 4 grounds of vacation. There will be how many? 4 grounds of vacation. Actually, point wise, if you see, there are only 3. But if you go technicality concept, you will be getting 4 grounds of vacation. But everyone who has given 3 or 4, both your answers are right. 4 who said, they might have read the point in 2 points, therefore they might have got 4. Are you understanding? So let us try to understand how to interlink both of them and read. And again, this is a complex concept, not that easy. It's not for mugging up. It's only for those who wanted interpretations. Any kind of question that comes in examination, you will be able to solve. Adi not guarantee. Okay. No, sir, we want only mugging up of concept. Shut the live and go and read. No, sir, we want concept interpretation as to how to understand. If a tough question comes in examination, then stay here. Okay. So the point is, what is this section talking about? Section 5 talks about disqualifications for becoming a partner. Section number 24.2 talks about vacation after becoming a partner. Vacation after becoming a partner. See here what I am going to do. For our understanding sake in the class, I am putting both the sections in one set. Okay, this is section 5. Let us have 24 also here itself, reference become easy. Okay, see now. So I have now kept 2 points side by side. Now let us try to make the necessary interpretation. See here. How to understand this? An individual or body corporate may become may be a partner in LLP. So individual can be a partner, body corporate can also become a partner. Number 1 completed. Number 2, individual shall not be capable, means he is disqualified from becoming a partner. Becoming, here is talking about future tense, becoming a partner of LLP if how many conditions are there? 1, 2, 3. If he has been found to be of unsound mind by a competent jurisdiction and the finding is in force, he is an undischarged insolvent, or he has applied to be adjudicated as an insolvent and his application is pending. Okay, next. A person shall cease to be a partner of LLP on his death or a dissolution of LLP, or he is declared to be of unsound mind by a competent court, and if he has applied to be adjudicated as an insolvent or declared as an insolvent. These are the 2 points given here. Okay, without any delay, let us now start with the conceptual discussion. See here. First, ground 1. Unsound mind. Ground 1, unsound mind. First, certain important things we wanted to discuss. Word used is unsound mind. He is not talking about insanity. Insanity is different. Unsound mind is different. Unsound mind means a druggist, drug addict, or alcoholic, extreme druggist. All these people are termed as unsound mind. They are having nice brain. It's talking about a mind which is talking about control. Okay, brain is a physical substance, mind is a emotional substance, brain is a scientific substance, mind is a legal substance. Okay, hospitals la brain operated. Okay, law la mind is analyzed. Your mindset will be analyzed in law, your brain will be analyzed in science. We are reading law, therefore mind won't come in medicine, brain won't come in law. First point number 1 clear. So we are not talking about unsound brain, we are talking about what? Unsound mind. That means emotionally he is imbalanced because of various reasons. So if a person is unsound, whether he can become a partner or not, question number 1. Okay, he is sound when he is a partner. After becoming a partner, he became a person of unsound mind. Can he continue? Is a question. Am I clear? Okay, see here. A is there, B is there. A said to B, B, you are unsound. Who said? A said to B, B, you are unsound. Okay, now B is what? Unsound mind. Wrong. A should not tell that. That's the first important point you need to understand. Who the hell A is to declare that I am unsound? If that be the case, all my enemies I will choose. One by one I will tell you are unsound, you are unsound, you are unsound. Automatically will they become unsound? Then every person who has a rival, they will tell you are unsound, they will become unsound mind then. So A is not the person to tell that B is unsound. Who should tell? That's why the word competent jurisdiction came. Competent jurisdiction. B belongs to Hyderabad. B belongs to Hyderabad. Hyderabad court will know better why B has become unsound than a court in Haryana and Punjab. Okay, P&H court is there. Punjab and Haryana High Court is there. Okay, person is residing in Hyderabad. Complaint to declare him as unsound is filed in P&H High Court. Punjab and Haryana High Court, they filed a complaint. Court will not even accept the complaint. Do you know why? Court will tell that complaint may be right, but the jurisdiction is wrong. Complaint may be right, but jurisdiction is wrong. You are from Hyderabad, na? Person is in Hyderabad, na? File a complaint in Hyderabad court. Yeah, they will take care of these particular proceedings. Understood the point clearly? So, Mr. A, Mr. B, Mr. C should not declare. Court should declare. Which court? Any court. Court of competent jurisdiction only should declare that he is a person of unsound mind. That's a number one. That is the relevance to the word. He has been found to be unsound by a court of competent jurisdiction. So, he should be found to be of unsound mind not by you and me, but by a court of competent jurisdiction. Not only that, and this is condition 1. Condition 2, finding is in force. What do you mean finding is in? The word used is in. Is in represents a present continuous statement. Means he is unsound 5 years back. Today he is not unsound. You can get appointed. Past unsound mind is not relevant. How do you know? The word used is, not was. If the word used is has been or was, even past unsound mind also will disqualify you in the future. But when I am unsound, I cannot become a partner. Once I become a sound, you can become a partner again. That's why, who found? Court found that you are unsound. That court finding must be in force. In force means it should be continuing. During that period of unsound mind continuity, you can't become a partner in LLP. After that, you can become a partner one more time. Clear up to here? Read the point number here properly. Everyone understood the meaning of finding is in force? Completed? Everyone listening to the lecture completed up to here? I continue? Yeah. See here. So, first thing, he is found to be of unsound mind by a court of competent jurisdiction and the finding is in force. Two conditions must be satisfied. Next, if you observe, point B of subsection 2 of section 24 also talks about the same. Means, if you are unsound before appointment, if you are unsound before appointment, okay, in that case, you can't become a partner. You became unsound after getting appointed. In such case, you are can't becoming a partner question does not arise because you already became a partner. Then what you have to do? You cannot continue. That's why cease to be a partner. That's why we call it as vacation of partner. Vacation of what? Partner. Repeat one more time. If you get attracted by unsound mind before becoming a partner, you are qualified or disqualified, or disqualified from becoming a partner. If your if your unsound mind is getting attracted after becoming a partner, then question of disqualification does not arise. You will be vacated from your office. That's why he will cease to become a partner. Okay, let's see. If he is declared to be of unsound mind by a competent court, in such case, your office will be completed or continued or completed, seized or continued or seized. It is vacated or disqualified or it is vacated with immediate effect. Okay, so let's read. If he is a person shall cease to be a partner of LLP if he is declared to be of unsound mind by a competent court. Now listen, we are going to merge both of them. So 24 to B. Let's read and understand. See here. Listen carefully. This timeline chart is very important. You can draw later. Please listen first. Okay. See here what happened. On 1/1/2024, on 30/6/2024, on 31/12/2024, on 1/1/2024, Mr. A filed a complaint against, don't write, I will give time. Please listen first. Mr. A given notice or complaint against Mr. B. Against B in a competent court. Raised a complaint against Mr. B in the competent court to declare Mr. B as unsound mind. Competent court declared Mr. B as a person of unsound mind. So, 6 months time it has taken for the court to declare that he is a person of unsound mind. Next, they know that he is unsound because of his drug addiction or because of his extreme consumption of alcohol, etc. He will be sent to the rehabilitation. Okay, they will do some medication on him. इलाज किया उनको. So completely he was taken care by a medico for around 6 months time. On 31/12/2024, Competent court declared that Mr. B okay, person of a sound party, means here represents declared that Mr. B as a person of sound party. Sound party represent not financially sound. Sound party means he is a party of a sound mind, or I will write correctly. Roughly I am writing all these. In the main charts I have shared you know LLP. There I have written everything in a clear format. Let's understand the concept clearly. See here. Mr. B filed a complaint against Mr. A filed a complaint against Mr. B in the competent court, declaring Mr. B as a person of unsound. Court has taken 6 months time. It does all the analysis, tests everything. Court hearings was all conducted. 6 months after court has declared that yes, Mr. B, you are a person of unsound mind. He was sent to the rehabilitation center where he was treated well, and after 6 months the court has redeclared that Mr. B is a person of sound mind. Okay, this is a point we completed till now. Now my question starts. Listen, don't see the charts. Which charts? Answer charts I sent you in the group. Don't open that. If you open, don't answer. If you don't see that, you please try to answer this query. Now the question starts. The point is, I will divide this into 3 stages. Stage 1, stage 2, stage 3. Okay. Now listen carefully to the point. First point number 1. This is the whole idea. Listen to my words clearly. Disqualification is like a disease. Vacation is like a death. Repetition. Disqualification is like a disease. Vacation is like a death. What is this, sir? Disease will be from a particular time to a particular time. Death will happen at a point of time. Disease, period of time, death, point of time. Disqualification, period of time. Vacation, point of time. Means period will be there for disqualification, period will not be there for vacation. Vacation happens at a particular time. Disqualification will happen for a period of time. I am disqualified from 30th June to 31st December. Okay. Or I vacated my office on 30th June afternoon 12 o'clock. This is the point. Am I clear? So period of time is represented by disqualification. Okay, point of time is represented by the concept called as vacation. Why I am discussing about this? Listen carefully. Listen carefully. Court declared Mr. B as a person of unsound mind when on 36 it has declared. Okay. Now tell me, from 36 2024, from 36 2024 till 31/12/2024, I am a person of sound mind or unsound mind? Unsound mind. I am a person of unsound mind. In that particular 6 months time, the concerned party is a person of sound mind or unsound mind? Unsound mind. Okay. So now the question starts. It will be from 36 till 30/12/2024. Are you understanding or not? So he is a person of unsound mind. This will be for a period of time. You got vacated your office. You have vacated your office on 36 2024. This is the point of vacation. Period will be from day to today. Vacation is for a point of time or point of vacation time. Anything you can call. Am I clear? So the question starts now. Three situations we have created. Let us understand one by one. First, Mr. B filed a complaint against Mr. A, filed a complaint against Mr. B in the court, competent court, to declare Mr. B as unsound. Disqualification or no disqualification? Why? Competent court didn't declare. A declared as to B. So no. When disqualification not attracted, question of vacation do not arise. Second said, competent court declared Mr. B as a person of unsound mind. Okay, Mr. B as a person of unsound mind. Okay. Point of vacation started. Now listen carefully. Court also declared. Who also declared? Court also declared. See the text here. Found to be unsound by court of competent jurisdiction and the finding is in force. Disqualification, yes. Start from 36/2024. Vacation, yes. That's also will get attracted. Okay. Vacation also get attracted. Next one. Declared that Mr. B is a person of sound mind. Okay. B is a person of sound mind. Okay. B is a person of sound mind. This period, he can be a partner. So, he is disqualified between what period and what period? 2 and 3. Next, on 31/12/2024, court declared that Mr. B is a sound mind. Disqualification, disqualification ends. Disqualification will end. Disqualification is for a period. Beginning will be there. Therefore, ending will be there. Vacation don't have beginning and ending. Vacation happens at a point of time. Therefore, vacation don't have any beginning and ending. Vacation attracted, not attracted is the question now. Okay, already vacation attracted, you become a non-partner. Question of vacation does not arise. Okay, this is all I wanted to convey. Why I said this, I will explain. Before that, tell me, on which date A filed a complaint against B? On 1/1 to declare him as unsound. Immediately he will become unsound? No. Wait till the court judgment comes. That's why disqualification, vacation, both do not attract. Next, declared Mr. B as a person of unsound. Court also declared. Now, two things happen at the same time. Disqualification starts, vacation gets attracted. Because of vacation getting attracted, you need to leave that particular firm. Okay, you need to leave that particular firm. Number one effect, vacation. And you cannot become a partner in that particular LLP as well. Next, third case. Declared Mr. B as a person of sound mind. Declared Mr. B. That means court only said that you are a person of sound mind. Okay, in that case, disqualification will end. Question of vacation does not get attracted because already vacation got attracted before that. Okay, listen, one important observation. See here. He is declared to be of unsound mind by a competent court. Why the words and the finding is in force is not there? And why the words and the finding is in force? Why that word is not there? The important phrase, why it is not there here? The reason is vacation gets attracted for a point of time, not for period of time. Finding is in force is a period. Okay, just if you get declared by the court as unsound, that's all. Your office will become vacant. It need not be for a period of time. Vacation happens at a point of time. Disqualification happens for a period of time. Okay, read this concept, write this chart as well, everyone. Important for understanding. Write down. First, every one of you should tell one answer. Are you all comfortable up to here? Right down here. Everyone understood the interlinkage between both the sections. One section is talking about disqualification, another section is talking about same ground covering vacation. Vacation is for a point of time, that's why finding is in force will not be there. This is for your reference. And by the way, I forgot to tell me, between stage 1 and stage 2, between stage 1 and stage 2, disqualification, vacation. Tell me, disqualification governed by section number 5, vacation governed by section number 24(2). Tell me, first situation, between 1124 and 3624, will there be any disqualification? No. So therefore, no vacation. Between 36 2014, is there a disqualification? Yes. Is there a vacation? No. Vacation is not for a period of time. Vacation is at a point of time. Reminding everything is same. Written the section numbers also, please copy down. Also understand this. Okay. Give a reply, everyone. Are you all comfortable up to here? Okay. Next. We have now completed 5 la A, 24 la 2 la B. 2 points completed. Second one. B and declared as insolvent. C point we are going to discuss now. Okay. Let's understand. He is an undischarged insolvent. He is an undischarged insolvent. Let me explain. He is what? Undischarged insolvent. So what do you mean by an undischarged insolvent? Let us understand. Okay. See here. Insolvency is of two types. Okay. Insolvency is of two types. Creditors filing a complaint against a debtor. Debtor filing a self-petition. Debtor filing a self-petition. There are two kinds of insolvencies, very popular two ways. Number one, creditor will file a complaint against the debtor. He will tell to the court, this fellow has taken loan from me, but he is not repaying even after the due date. I kept on reminding him about the payment, but he is not responding. I have given him a notice. He ignored the notice. Please take some legal action to sell his properties. Get back my amount. Like this, we will put a urge to the court, asking the court to take an action against the person to recover my dues. This is the basic ideology behind the concept of insolvency in India. Okay. For that, there is one separate act called as Insolvency and Bankruptcy Code. CA final it will come. So at CA final level, we will discuss in depth about the concept of Insolvency and Bankruptcy Code. From its grandfather, I will tell you how this act has come. But here, that's not the intent. But we should know what is insolvency. See here, there are two types of insolvency. Creditors putting a complaint, debtors making a self-complaint. Okay, creditors putting a complaint, section number 789 of Insolvency and Bankruptcy Code will apply. Debtors filing a complaint against themselves, section number 10 covers it. So all these are covered by separate act of parliament called as Insolvency and Bankruptcy Code. Okay, why we are discussing about this now? Listen. Very interesting area, listen. Creditor filed a complaint against a debtor saying that, Koushik Mukhesh, you are insolvent. That's all. Koushik Mukhesh will not become insolvent. Like how if you tell against a person that you are unsound, he is not becoming unsound, court should declare. Insolvency also should be declared by a court only. Okay. Insolvency also should be declared by a court only. Listen carefully how it applies. Okay. Now, I want attention. All the students who joined live, attention please. Listen carefully. Okay. Listen. Those who are participating live, please don't go out of the live and come back again. If you are not in live, no problem. But if you are in the live, participate and complete it now. Okay? Let us understand. Participation required. See here. On 1/1/2024, 36/2024, 36/2029. Let us say creditor filed a complaint against a debtor before court called as a DRT. DRT deals with all insolvencies in India for individuals. Companies na NCLT will take care. Individuals na DRT will take care. DRT, Debts Recovery Tribunal. What is the name? Debts Recovery Tribunal. So this Debt Recovery Tribunal will be doing recovery of debts. Name lone clear. Debts Recovery Tribunal. There you have to file a complaint. This Debts Recovery Tribunal is a court in our case. Okay. So creditor filed a complaint to a debtor. Okay, complaint against a debtor. before DRT. It's a court. Okay. Now question arises. Disqualification, vacation. Attracted, not attracted is a question now. Is a question now. That means, will the disqualification attracted just because of a fact that I filed a complaint? Sir, if that be the case, I will file a complaint against Mukesh Ambani today in DRT. The moment I make a complaint, Mukesh Ambani becomes insolvent, disqualified, no. So, you just filed a complaint. Court has to see that application, analyze. As per Insolvency Act, it should confirm. So, immediately on making a complaint, no disqualification, no vacation. Okay, next. On 36/2024, court, DRT, declared that Mr. B being a debtor is insolvent. So who declared? B declared. Court declared. Whom? Mr. B as solvent or insolvent. Now, once he is insolvent, insolvency will start now. Start when? Start here. Continue till when? Court said that you will be declared as insolvent for 5 years. Like how you are imprisoned in a jail for 5 years, insolvency also has a period. Court said that you are insolvent for a period of 5 years. How many years? 5 years. This period is, I am inside the insolvency. I came out of insolvency. During that time frame, 1, 2, 3. Between 2 and 3, I am inside the insolvency. I am out of the insolvency. I am inside the insolvency. That's the point here. There is a hospital. A person entered into the hospital, stayed there. You will call him discharged, not a discharged. He came out of hospital. You call him discharged, undischarged, discharged. Undischarged insolvency leads to disqualification, which means this period between 36/24 to 36/29 will be called as UDIP. What is UDIP? Undischarged insolvency period. Undischarged insolvency period. Okay. Undischarged insolvency is for a period declared on 36, declared from 36 to 36/2029. Period disqualification, point of time vacation. That's why if you see, when you see the vacation section, how beautifully the lawmaker used the words, if he has been declared as an insolvent, not undischarged. Undischarged is a period. Declaration is on a day. That's why whenever sees vacation comes, they used only declared as insolvent. Over. That's all. Okay. So now the question arises. Disqualification will get attracted in the second case or not? Yes. Vacation will get attracted or not? Yes. Disqualification will be for a point, a period. Till when? Till 36. Court redeclared Mr. B being a debtor as solvent. Means what? I am discharged. Whenever I am a discharged, section covers undischarged only. Since I am discharged, no more I am disqualified. Okay. In this case, disqualification ends. Yes. Vacation ends. No. Vacation don't have starting and ending. Vacation gets attracted. That's all. Beginning ending will not be there for vacation. Disqualification will be for a period. Beginning ending will be there. Sir, a person is suffering from a disease from 1st April to 10th April. I can tell. He started dying from 10th April. Died. April 10th he died. Death is at a point of time. Yeah. Disqualification is like a disease. Okay. Likewise, disqualification will be for a period. Vacation will be like a death, which is for a point of time. Okay. This is the point that I have to convey. So, if you want the section numbers, I can tell this way. Between 2 to 3, between 1 to 2, section 24 will not get attracted. Section number 5 also won't get attracted. Okay. Next, between 2, 3, section number 5 gets attracted. 24 won't get attracted. 24 gets attracted on the date, not for the period. Okay. Lastly, section number 25, section number 5 will stop getting attracted. 24 anyway, it is not attracted. Okay. This is the idea behind this concept here. I am putting it before you. Just read. Before we continue to the next, hope every one of you understood the concept clearly. One reply. Understood the insolvency concept clearly. Okay. Read the diagram properly. See the time chart. And I am telling you again and again. This is the unique time chart which I prepared after understanding the entire structure of the Bail Act. Okay. So make the best use of the time charts. And I am telling you again and again. No one in India has made an attempt to understand LLP disqualifications this way. You check any kind of YouTube video regarding this LLP concept. No video explains you about disqualifications read with vacation with this much of explanation, explaining you how the interlinkage happened between two sections. So please make the best use of it, understand it properly. Any kind of question that comes in exam, we will be able to solve. Read it properly. Understand the chart properly, everyone. Whatever I explained. Last 1 minute, please analyze the chart properly. Understand the dates. And second thing, which sections get attracted for which period. Understand that also properly. Once you are done, put a message. I will start with the next part of insolvency concept. I think audio problem came, right? Yes, yes, yes. Their battery over. Now it is audible. Now is it audible? Okay, let's continue. So what I said is, we have completed the following things now. What we completed? A completed, corresponding B completed. B completed, corresponding C the second part completed. C we are going to start now. Corresponding we are going to complete C the first part. Okay, let's read. He has applied to be adjudicated as an insolvent. He has applied to be adjudicated as an insolvent. And his application is pending. I told you there are two types of insolvency petition. Number one, creditor filing against a debtor. Second one, debtor filing on him. Okay, debtor filing a application on him. That means debtor he himself can also apply for insolvency. That's what the situation they wanted to cover here. Okay. So if he has adjudicated and his application is pending, means during that pending period also disqualification will be there. Disqualification is for a period, vacation will be for a point of time. Therefore the term his application is pending you will not find here. Okay, just apply to be adjudicated as insolvent, that's all, over. Okay, applied to be adjudicated as an insolvent, that's all, over. The second part already we completed. So if he has applied to be adjudicated as an insolvent, that's all. That moment you make application, vacation gets attracted, for the entire pending period of judgment you will be disqualified. Let us understand how this will apply, and we will merge point C with point B as well. Okay, very complicated concept, listen carefully. See here. Okay. Okay. Now, see here. Let us say this way. Okay. Mr. B, debtor, files a self petition in a competent court, obviously DRT, to declare himself as insolvent. The logic of the law is very clear. When B he himself is saying that he is an idiot, why should court say no? If someone says you are an idiot in the court, court will tell that why should I believe you? Let me inquire and tell whether he is an idiot or not, it will tell. Complainant he himself is telling that court, I am an idiot, please declare me as idiot, means prima facie court believe that you are an idiot only. But it will do its analysis. Okay, but prima facie, in the first opinion, it will tell that yes, you are an idiot, because you are only telling that you are an idiot, not some other person claiming you. You yourself is claiming that you are the biggest idiot on the planet. Then why court should say no prima facie? So beginning lie will not say no. I will believe that you are an idiot and I will start the analysis. That's what the point in this. Okay, let's understand. Mr. B, being a debtor, made a self petition in a competent court to declare himself as an insolvent. Law is saying that your disqualification will start. Your disqualification will start. The moment you file a petition, disqualification will start. Okay. Now, sir, all our examples, we have an assumption. Whether first chart or second chart or third chart, in all the charts we have an assumption. Do you know what is assumption? Assumption is I am already a partner. Assumption is I am already a partner, because you will get attracted by disqualification before becoming a partner. But vacation gets attracted only if you are if you are a partner. Therefore, we are all doing this question from the point of view that you are a partner. Later, you came to know about these disqualifications. Okay, let's understand this. I became a partner. After becoming a partner, 2 years after, 1/1/2024, I myself applied to the court. Court, please declare me as insolvent. Okay, because I don't have proper assets to pay the liability, I am insolvent. Okay, B himself said. Court will tell that, okay, for some time, for temporary period, I will believe that you are you are insolvent. Therefore, your disqualification will start the moment you apply. This is said in section 24. Okay, subsection 2, clause C. Once you apply, the moment you make application, you are ceased to continue as a partner. Okay. Vacation, yes, attracted. Vacation don't have starting ending. Vacation have only attraction. Sir, which section said the disqualification will start? This is said in section number 5. Okay, section number 5. Vacation is said in section number 24 2C. Next, you tell me, I will listen. Everyone participating live, tell me. Now, I am insolvent at stage 1, stage 2, stage 3. Here I became insolvent at stage 2. Here my insolvency will be from stage 1 to 2, stage 2 to 3, stage 1 to 3. I repeat the question one more time. Everyone participating live, please answer. My disqualification will be from 1 to 2, 2 to 3, or 1 to 3. Okay? Okay. See here. There are two answers. There is no one answer for this. That's what I want you to answer. There are two answers. On 36, two situations can come. Court declared Mr. B as insolvent. Second situation, this is A. Situation B. Court declared that, array, that's a fake application. This debtor wanted to escape from the creditors with the intention to cheat the creditors. He's telling that I am insolvent, don't touch my assets. Declared that Mr. B is not insolvent. B is not insolvent. Two situations can come. If court declared that Mr. B is insolvent, court declared that Mr. B is insolvent. If court declared that Mr. B is insolvent, then disqualification will start or will not start? Will not start, because it has already started. So it will continue. It will continue. Separately, no section attracts. Already attracted. Vacation. Attractor will not attract, because already he is vacating. He vacated office 6 months back. Next, declared Mr. B is not insolvent means he is declared as insolvent or not declared as insolvent? Not declared means undischarged insolvency won't get attracted. What will not get attracted? Undischarged insolvency won't get attracted. Therefore, disqualification will end. Disqualification will end. Vacation dash. Okay, this is the point here. So if the situation is A, disqualification will continue till 31/12. So in situation A, this is the undischarged insolvency period. This is what we have already seen in the previous example. Okay, so this is one important observation. Everyone listening live understood the concept clearly? Yeah. First tell me, chart everyone understood properly? Understood the chart properly, everyone? Adjudicated, adjudged, both are same. Both means verdicted, judgment. Both. Adjudicated, adjudged gives the same meaning. Essentially, both are same. You will reply, everyone. Understood the concept clearly? Okay. Now see the screen. See here, I have given a full view of how this has to be understood. Take time, read the chart properly. No mistake should be committed in exam. Completed? So whenever a self petition is made for insolvency, observation required on stage 2. Stage 2 two situations can happen. At stage 2, two situations can happen. Situation number 1, petition is accepted or rejected. Situation 1 is rejected. Situation 2 is accepted. If your petition is rejected by the court, okay, then your disqualification will end with stage 2. If petition is accepted by the court, then your disqualification will continue till stage 3. Okay, so you will go to stage 3 if and only if your petition is accepted. That's why I have again written petition rejected, not applicable, stage 3. If petition is accepted, disqualification will end at stage number 3. Okay, so this is the point. Everyone understood? Okay. Some people who completed CA inter is also coming live. That person, Abhita, why you are coming live? What is the use? Complete, everyone. Okay, so now we completed section number 5 of LLP, read with section number 24. So let's now complete of the remaining portion as well, one by one after another. So come back to section number 5. So the interlinkage is completed. Come to section number 5. The concept of partners is completed. So the point is clear. Only individual and other persons recognized by law can become partners in a LLP. Means LLP cannot entertain other than recognized legal persons to become the partners. Simply to tell, a partnership cannot become a partner in a LLP. To become a partner in LLP, you should be legally recognized person like individual or any other body corporate. So this is what we discussed. So A, B and C, all the three are completed. Following persons can become partners in LLP. Following persons can become partners in LLP. Who are they? Let us see. Individuals, residents, including NRIs and overseas citizens as well as foreign nationals. LLP can become a partner. Companies can become a partner, including foreign company, because foreign company may not be a company, but foreign company is a body corporate. LLP outside India, foreign company. Cooperative society and corporation sole cannot become a partner, because yesterday's discussion we already made it very clear that body corporates, sole proprietor concerns and cooperative societies will not be included. Okay. So with this, we completed another important section called as section number 5. Section number 25 subsection 2 main part also completed. Okay. Next. Minimum number of partners. How many? Minimum number of partners. Every LLP shall have at least 2 partners. Shall have at least. When I say at least, it represents minimum. If at any time the number of partners of LLP is reduced below 2 and the LLP carries on business for more than 6 months, while the number is so reduced, the person who is the only partner of LLP during the time that it so carries on the business after those 6 months and has a knowledge of the fact that it is carrying on the business with him alone shall be liable personally for the obligations of LLP incurred during that period. Ditto copy paste to section 3A of Companies Act. Most of the sections of LLP chapter are similar to Companies Act. Okay, this is a ditto, not 50%, 60%, 99.99% copy. Whenever the word partner comes, there the word members will come. Here the word partners will come. But still, it is in my obligation to discuss about the concept. I'm not telling I'm going to leave because it is there in Companies Act. I'm telling this is there in Companies Act. That's all. Okay, but make your effort. Try to understand the concept. Go into analysis. Completed? Okay. Let us now try to analyze this particular section. See here. Every LLP must have two partners. Pakka. But you can't stop the death. You can't stop the death. Two partners are there. Two partners started the LLP. Okay. Okay. Today they started the business as a LLP. They continued for 5 years. Two partners are there. On a particular day after 50th year, one of the partner resigned and went away or died. Something happened. Sudden occurrences happened. Because of that, two became one. Two became one. No offense committed. Law said that you can continue like that for a period of 6 months. So 6 months period also over. Even after 6 months, still there is only one person. That one person will become liable personally for all the debts incurred during this period only. Means this period two partners are there. LLP liable. This 6 months period, one person only there, but 6 months grace period is given. LLP liable. Even after this, knowingly you continued and does the business now, then you will become personally liable. After that, after 1 year, they appointed another partner, made it two. After this, again LLP will be liable. That means every time liability of LLP is a liability of LLPA because of separate legal existence. However, in one single case, liability of LLP will become the liability of one partner, in which case there should be two partners, but there is only one partner. One of the partner vacated, there is only single partner for a period of 6 months. Okay, even after a period of 6 months, if you still continue to do the business knowingly about the exit of a partner, then that one partner will be there na, he will become personally liable. Logic is very simple. How many are required? Minimum two. How many you have? One. Okay, six. Asal two persons place la one person a crime, but lawmaker is kind hearted. He has given 6 months time. Even after 6 months you are not filling it, therefore that single partner continued as a single partner even now. Okay, when there is only single person, you will call it as a LLP as sole proprietary concern. Sole proprietary concern. Sole proprietary concern, full liability is with whom? Sole proprietor. That's what he is also telling. 6 months I tolerated here. Even after 6 months, only one person is continuing. Then why should I call it LLP? Don't call him as a LLP. Call it as a sole concern. Till you appoint another partner in a sole proprietor concern, who will be liable? Sole proprietor will be liable. Therefore, you will be fully liable. That's what he wanted to tell. Hopefully everyone understood. Tell one yes, we'll continue. Tell one yes, we'll continue. Okay, next. Designated partners, don't read now. Okay, don't read now. Let us first come to one concept called as liabilities of designated partner. Liabilities of designated partner. So, who is a designated partner? Any partner designated under section 7, means previous section. Any partner designated under section 7 is called as a designated partner. Name lone clear, designated partner. First he should be a partner. After becoming a partner by LLP agreement, you will be declared as a designated partner, which means whenever some legal compliance is there and it is a non-compliant, you only will become liable, not all the partners. Simply they take responsibilities of legal compliances. Okay, responsibilities of legal compliances. Decision making comes, all partners will take a decision. Okay, let's read. Unless expressly provided and otherwise in this act, means otherwise means differently. A designated partner shall be responsible for doing all acts, matters, and things as are required to be done by LLP in respect of compliance of provisions of this act. Which compliance? Legal compliance. Means he is responsible to take care of, he is responsibility to do such things for the legal compliances under this act. Simply give me some examples. That's why including example. What are the examples that were given? Filing of documents, return statement, reports, etc. Anything. Okay. And liable to penalties. If you do not do that, I will call it contravention. For contravention, all partners liable, only DPs are liable. Only DPs are liable. As simple as that, answer completed. So tell me, what is the liability of a designated partner? Number one, responsible to doing all the acts, duties, and compliances under this act, like filing the document, returns, reports, etc. And if not filed, you will be liable for the penalties. Next, like directors, company directors will change, like that in LLP, designated partners will change. See there, what they are saying. A LLP may appoint designated partner within 30 days of vacancy. Within 30 days of vacancy means any vacancy caused in the office of a DP must be filled within a period of how many days? 30 days. For any reason, and provisions of subsection 4 and subsection 5 of section 7 shall apply. 7 we didn't read, leave that part. Shall apply in respect of such a new designated partner, provided that if no designated partner is appointed, or if at any time there is only one designated partner, each partner shall be deemed to be a designated partner. Important, read this. Okay, sir, 8th section, 9th section, 10th section, not there at CF Foundation. These are new sections added for inter. Therefore, chance is there 8, 9, 10 can come in exam. Any of those can come. Read this. Section number 8, section number 9. 8 completed, read 9. Read it properly. Okay. So let's continue. See here. A LLP may appoint designated partner within 30 days. See here, first point number 1. LLP, okay, may appoint a DP within a period of 30 days of vacancy for any reason. What do you mean by may appoint? For example, how many DPs are required? 2 DPs are required. I am having 4 DPs. One person resigned and went away. Then it is may. There is no mandatory thing here. Two people resign. Still we have two na. Again, filling is optional only, not mandatory. Okay? But if no designated partner is appointed, means only two designated partners are there, both of them went away. Only two designated partners are there, both of them went away. Or only two designated partners are there, one went away, one is there. In a partnership, in a LLP, A1, A2 are partners. B1, B2 are designated partners. Okay. Now, how many partners are there totally? 4 partners are there. In this, B1 went out. Then only one DP is there na? Any one of them, A1 or A2 should act as a DP. Both of them went. No designated partner. Then both of them will be deemed to be designated partners. That's what he wanted to tell. If no designated partner is appointed, or if any time there is only one designated partner, each partner shall be deemed to be a designated partner. Okay. Next. Punishment for contravention of section 7 and 9. Okay, 7 we didn't discuss, 9. The penalty sections, always I tell that prepare a table and write down the penalties. Nothing is there to discuss. Even in Companies Act, I don't discuss them. Companies Act, what I will tell, refer penalty chart. Penalties are for your remembrance, not relating to the concept or any analysis inside it. Clear everyone? With this, we completed section number 8 and section number 9 and section number 10. It's only a penalty section. Nothing great to complete. Next, let's complete designated partners section 7. Every LLP shall have at least 2 designated partners who are individuals, and at least one of them shall be resident in India. So first, how many designated partners? 2. In that, one must be a resident of India. Okay, and they must be individuals only, because they have to pay penalty. You can't punish, you can't keep in jail if it is a body corporate. Therefore, DPs must be individuals. So therefore, 2 DPs who are individuals, and at least one among them should be resident. Both are resident also, no problem. But at least one must be a resident. Provided if in LLP all partners are body corporate. Partners are body corporate. All the partners are body corporate. Or in which one or more partners are individuals and body corporate, means combination is there. At least 2 individuals who are the partners of LLP, or if individuals are not there, individual nominees of such body corporates shall act as a designated partner. Simply, how many designated partners are required? 2. In my LLP, there is no individual partner. All partners are body corporate. 5 partners are there. All the 5 are X Limited, Y Limited, Z Limited, A LLP and B LLP. Either LLPs are there or companies are there. That means my partners are body corporates. In such case, what I have to do is a question. Then the answer is like this. If all the partners turns out to be body corporates, or combination of individuals and body corporates are there, in such case, at least 2 individuals who are partners of such LLP, okay, either this, or if they are not there, nominees must be individuals. Nominees of such body corporate shall act as a designated partners. For example, Mr. A and A Limited is there. Mr. A will become a designated partner. A Limited will nominate one individual who will become the designated partner. A LLP has 3 partners, one individual, Mr. X, and 2 body corporate, namely XYZ. How to do? X will first become a designated partner, and XYZ or ABC Limited, both of them should appoint one nominee. In this case, Mr. X and one nominee of any body corporates shall be the designated partners. A LLP by the name SMY LLP has 3 partners, namely S1 Limited, MIS Limited, YI Private Limited. There is no individual as partner in LLP. Nominees of any of the 2 said body corporates shall act as a designated partners. What does it mean? He is saying that there is no individual at all. In such case, no individuals, any 2 of the body corporates has to choose one nominee to become a designated partner. Next, resident means not less than 120 days he should be there during the financial year. Next, if the incorporation document specifies who are to be designated partners, such persons shall be designated partners on incorporation. Sir, what is this? Incorporation document will be like SPICE document in Companies Act. In Companies Act, we require SPICE document to incorporate company. In LLP, there is a document called as incorporation document. In the incorporation document, I mentioned Mr. A, Mr. B will be designated partners. Automatically, AB will become designated partners upon incorporation. Okay. Next, I didn't mention the names. If the incorporation document states that each of the partners from time to time of LLP is to be designated partners, every partner shall be designated partner. Means if I write that all partners are designated partners, then every partner in the LLP will be both partner as well as designated partner. Any partner may become designated partner by or in accordance with LLP agreement, and a partner may cease to be designated partners in accordance with LLP agreement. That means at the time of incorporation, two ways you can become DP. Number one, write the name. Number two, write that all partners are DP. Over. After getting incorporated, I wanted to bring a new person. How to bring? Through LLP agreement. How to send him out? Again through LLP agreement. So before incorporation, post incorporation. Before incorporation document through he has to come. Post incorporation, he has to come either through LLP agreement and he has to go by LLP agreement. An individual shall not become a designated partner in any LLP unless he has given prior consent to act as such. Simply, what is required? Consent is required to become a designated partner. Next, every LLP shall, with the registrar, file with the registrar particulars of every individual who has given the consent as designated partner within 30 days. Means this consent has to be filed with ROC within 30 days. Next, an individual eligible to be designated partner shall satisfy the conditions as may be prescribed. These are said in the rules, and rules are not applicable for exam. So leave it. Every designated partner, how directors have DIN, designated partners will have DPIN. Okay. So section 153 to 159 of Companies Act will apply. So every designated partner of LLP shall obtain DPIN. Directors ki director identification number. DPIN means designated partner identification number. That's all. With this, we completed section number 6, 7, not only section 6, section 5, 6, 7, 8, 9, and just a penalty provision 10. Over. Second set of this chapter also has been completed. Okay, I'm stopping here. Next, maximum today, maybe after 8:30 I can join live if time permits for me. If not, tomorrow we will be having one session on FM debtors management. Once that is completed, I will start with the LLP concept, the balance part as well. Okay, I told you 3 hours it will take. In that 1.5 hours we completed now. Another 1.5 hours is there. There we will complete another 15 sections. Small sections will be there, which are similar to that of Companies Act. We will cover those. Once those are also completed, we go to the remaining part and complete them. Okay. Thank you very much. Prepare well of the part that is completed now.